Federal High Court in Abuja has ordered First City Monument Bank, FCMB and Nigerian Army to jointly pay the sum of 416,650,000 naira as damages for conspiring together and illegally placed Post-No-Debit (PND) without valid court order on the account of a bank customer, Major Akeem Adorogba Oseni, who was sentenced to 10 years imprisonment for manslaughter. The court in its ruling noted that FCMB may have acted out of fear of the Nigerian Army, but the court ordered both FCMB and the Nigerian Army to jointly pay the sum of 100 million naira as general damage and 300 million naira as exemplary damages as a deterrent to the bank and the military institution, that none of them is above the law or have the right to usurp the powers of a law court or deny a bank customer the fundamental right to own a movable and immovable property anywhere in Nigeria as enshrined in the Constitution. It would be recalled that the Nigerian Army officer, Major Akeem Adorogba Oseni, in 2020 was convicted by a general court-martial in Abuja, and thereafter he escaped from court premises and was later apprehended in Benin Republic at the Cotonou International Airport around. Major Oseni was one of 3 Army personnel jailed in February 2020 for 10 years over the death of a Lance Corporal, Benjamin Collins. Some soldiers were detained and were quizzed by the Army headquarters garrison in relation to how Oseni escaped in the first instance. But Court of Appeal later set Oseni free from the manslaughter conviction. Justice G.K. Olotu of the Federal High Court in Abuja gave the order in a judgment delivered on October 28, and whose certified true copy was made available online by family and friends of Major Oseni. According to the court document, the applicant, Major Oseni, had sued the Nigerian Army and First City Monument Bank as first and second respondents respectively in a suit marked FCMB CS 1104/2021 for placing his account on a Post-No-Debit from February 2020. The applicant had in a fundamental human rights suit dated September 13, 2021, and filed on September 22, 2021, so 13 reliefs, among which are a declaration that the act of the second respondent, FCMB, placing the personal account of the applicant domiciled at First City Monument Bank, with account number 26561520013 on Post-No-Debit from February 2020, till date on the directives of the first respondent, Nigerian Army, without a valid court order, now affording the applicant adequate time and facility to be heard, is illegal, wrongful, unlawful, and constitutes a blatant violation of the applicant's fundamental rights to a fair hearing, the presumption of innocence, rights to own movable and immovable property anywhere in Nigeria as enshrined in sections 36, 136, 5, 43 and 44 of the 1999 Constitution of the Federal Republic of Nigeria as altered, Sections 1, 1 and 2 of the Administration of Criminal Justice Act, 2015, and Articles 2, 3, 2, 4 and 7, 2 of the African Charter on Human and People's Rights, Ratification and Enforcement, Act A9 Laws of the Federation of Nigeria, 2004. A declaration that the dehumanization of the applicant by the operatives of the first respondent, while in their custody for 10 months, is illegal, wrongful, unlawful and constitutes a blatant violation of his fundamental human rights as enshrined in sections 35, 1, 3, 4, 37 and 41, 1 of the 1999 Constitution of the Federal Republic of Nigeria as altered, Sections 1, 1, 2 and 30, 1, 2, 32, 1, 2 and 3 of the Administration of Criminal Justice Act, 2015, and Articles 6 and 12 of the African Charter on Human and People's Rights, Ratification and Enforcement, Act A9 Laws of the Federation of Nigeria, 2004. A declaration that the continuous denial of the applicant's access to his funds is a blatant disregard of his constitutional provision to own movable and immovable property, as there was no court order granted to that regard, therefore illegal, wrongful, unlawful and constitutes a blatant violation of the applicant's fundamental rights as enshrined in sections 35, 13, 41, 1 and 43 of the 1999 Constitution of the Federal Republic of Nigeria as altered, and sections 1, 1, 2, and 30, 1, 2, 3, 2, 1, 2, 3, 2, 1, 2, and 3 of the Administration of Criminal Justice Act, 2015, and Articles 6 and 12 of the African Charter on Human and People's Rights, Ratification and Enforcement, Article A9 Laws of the Federation of Nigeria, 2004, among others. The applicant's account was placed on PND following the manslaughter investigation that allegedly took place in his office. The applicant, who was a field officer the week an attempted jailbreak occurred, was asked alongside other officers to take out the soldier, drill and relocate him to a separate detention facility within the cantonment. The soldier was afterwards handed over to the applicant to drill, frog jump, forward roll and counsel, which he did as instructed. Later that day, the applicant was told that the soldier was struggling with his leg cuff. He was rushed to the Defense Medical Headquarters where he was confirmed dead after arrival. The applicant was court-martialed by the Army and pronounced guilty of manslaughter, thereafter sentenced to 10 years in prison. The Court of Appeal, however, discharged and acquitted the applicant in a landmark appeal on October 31, 2022, and he was released from Kuje Correctional Center on November 1, 2022. Upon his imprisonment, his account was placed on PND, restraining him from accessing money for his family, according to Punch newspaper. The court, in its judgment according to the copy made available as news item, held that the evidence before the court shows that respondents acted arbitrarily and over their powers in their dealings with the applicant, particularly in these respects. The joint action of the respondents to place the personal account of the applicant on a post-no-debit since February 2020 till date, without a valid court order or affording the applicant the right to be held as constitutionally guaranteed. The action of the first respondent to conduct a search in a Gestapo manner and remove cash and valuables from the applicant's private apartment without a valid search warrant. The dehumanizing treatment of placing the applicant on handcuff and leg chain while in the custody of the first respondent before the confirmation of his sentence by the Army Council. Failure of the first respondent to grant bail to the applicant within 24 hours or 48 hours of his arrest, detention pending confirmation of his sentence by the Army Council. Justice Olotu therefore ruled that the first and second respondents connived and conspired to illegally freeze the applicant's account. The first respondent usurped the power of the court to order a freezing of the account by instructing the second respondent to freeze the applicant's account. Ironically, the applicant's finance was not implicated in the investigation of the case of manslaughter against him. And the second respondent, knowing better, either for fear of the first respondent or for reasons best known to it, obeyed the first respondent's instructions and froze the applicant's account. Whatever angle their conducts are viewed from, they acted clearly outside their powers. They probably thought that they were above the law, but the principle of exemplary damages will now tell them and show them that they are not above the law and that the law has no respect for anyone who breaks it. It was a big stick which it used and will now use to correct the abusive and excessive tendencies of the respondents. The first respondent also acted more than its powers in dehumanizing the applicant. The applicant claimed the sum of 2 billion naira award of general and exemplary damages. I award 100 million naira as general damages and 300 million naira as exemplary damages against the respondents jointly and severally in favor of the applicant, Justice Olotu held.
Bringing you the news in a more digital way.